Ryan, if you only had 1 minute to give music artists the best advice you possibly could, what would you say? 1 minute on the clock, starting now.
Protect your rights and understand the business. If you don't and you have any type of success, buckle up for a lengthy and expensive legal battle. For each and every song that you have out there, be able to answer this question: who owns your master and who owns your publishing? More importantly, what contracts exist that confirm that? I'm talking split sheets, work for hire, producer agreements, collaborator agreements. Have these things in writing. Text messages, DMs, all that stuff can go away. If you ever have success in the future, you want to be able to confirm who owns what. You don't want to have something where you're working with Andrew and the song blows up and everybody's happy. That's when all the collaborators come out of the woodwork and ask for their money. So you want to be able to have those rights locked in and understand who's owning what. But also you want to make sure that you're collecting your royalties. PROs, MLC, Sound Exchange, make that money, collect that money.
Damn. Exactly 1 minute. Good job. So you're the first. Well, I guess what your official title is entertainment lawyer. I think, right? You're the first person with any legal experience at all that I've had on my channel / podcast or wherever people are watching this right now. And so I'm super excited for that because I know almost nothing about it other than when I read on the internet. And one of the first things you hear anytime you look at anything legal is don't just blindly trust the internet or ChatGPT, talk to an actual lawyer. And so for everyone interested, Ryan's links will be down below for you to check it out and find him, contact him, hit him up. But yeah, you specifically talked about make sure you have everything in writing, have contracts in place so that everyone knows exactly what they're owed and who owns what.
Absolutely.
Let's say someone does just have an email chain or a text thread and they print it out, for example. Like, does that give people any protection? Like, let's say someone already, a few years ago, they worked in a track. They have proof in text and proof in email that like, hey, we agreed to this. And then now it's modern day and the song's blown up. Is that good enough if that someone were to take them to court and say like, hey, we didn't agree to this?
It can be, so long as it has the proper legal elements. For a contract to be enforceable, it has to have an offer, an acceptance, and consideration. An offer just, I will do this in exchange for that. An acceptance, yes, I agree to that. And the consideration is the mutual exchange of value. Andrew, I'm going to pay you $500 to play guitar on this track. And we exchange that and we're good to go. If that has those elements, then it can arguably be a enforceable contract. There's no requirement under the law that it has to be in a signed Word document, right? It's just, is there evidence that the parties agreed to the terms that they want to be bound by? I think that emails are much safer than text messages just because they're a lot less likely to get deleted and lost over time. You can have a thread and you can have a timestamp and all this. And unless you, for whatever reason, your email got hacked or you just deleted your Gmail account, you're going to have emails for years and years and years. And that's pretty safe. Phones, on the other hand, a number of things can happen. You could lose your phone. It could fall into the toilet. It could get crash, and then all those text messages are gone. And then there's also people that just, by habit, just delete text messages. So that one is a little harder, and it's a little bit easier to manipulate text messages. I could create a contact in my phone and say it's Andrew, and it's not actually Andrew, and we could have the conversation like it was you and I, right? Emails are generally a little bit more reliable, but really anything that has that confirmation of ownership is going to be helpful. I always say these agreements can be really, really simple, even if they are in a signed contract. A split sheet can be a one-page agreement. Just who's going to own the publishing for the song? Does everybody agree on that? Sign it. Then we're good.
Yeah, I own a label with a few artists, and usually the way we get started working with them isn't with some elaborate contract that we had a lawyer like spend a bunch of time doing. Like it's usually just like a one-page, very simple agreement that's like just kind of like bullet points of what we're going to do, what the artist is going to provide us, what the relationship is. And then eventually once we figure stuff out, we get something more more like official in writing. And that's, we've never had any issues, fortunately, but it's good to hear that it doesn't have to be anything fancy, because usually like it's just a time thing, right? Like if you're trying to work with an artist and you want to get going like next week, you can't present someone with like a 50-page complicated thing, and no one really wants that anyways. Like people want short and sweet, but like it's nice to be able to give them like a half a page thing temporarily that like just kind of covers all the important stuff, and then like a month later get back with like the 2-pager that has, or 3-pager that has like more.
No, I think that's totally fine and appropriate. And that's actually what a lot of labels do. They will sign an artist on a short form agreement, and then if they need the protections of a longer agreement in the future, they'll upgrade to a long form.
You've had some issues of your own with labels and stuff in the past and deals. We're going to get into that. But I want to go over like what are some of the most common legal issues, contractual issues, problems artists face that you see, either like in the contracts they're signing for labels that eventually bite them later, or any other related kind of things.
Well, as we discussed at the top of the episode, one of the biggest issues is just not having proof of ownership. I'm dealing with this right now for a client who has grown their career independently to a place where they've got a sizable catalog that's worth some real money, and there's somebody that wants to buy this catalog. But they don't have any contracts with their producers. Their contracts, if they did use any type of beat lease companies like BeatStars, those contracts don't give them the rights to sell certain songs. So there's a lot of legal work that we're having to do on the back end to put it into position to even sell. If this was all done on the front end, it would have been a lot easier. And I'm not saying that that's going to necessarily ruin this deal. We, as lawyers, we're creative and we'll figure out a way to make it happen if it works for everybody. But things do happen over time. If your producer, you have a falling out with your producer, or they move away and you don't have their new number, then you might not be able to get these contracts to confirm these rights.
So you mentioned that like in the case of trying to sell, which obviously isn't a scenario that most artists probably won't face, unfortunately, because that's probably a fantastic revenue stream for the people with a sizable catalog with good revenue streams. So I guess more from the flip side, on the more indie perspective, like artists who maybe only been around a couple of years, maybe have less than 100,000 monthly listeners. Do you see any kind of common pitfalls, traps that they find themselves in?
I do see a lot of smaller artists either fall into scams or fall into companies and labels that don't have their best interest at heart. Especially on the scam side, it's so common that in the age of automations and AI, it's very, very easy for scammers to reach out to any number of artists on SoundCloud and Instagram and whatever and say that they are the CEO of Universal and they're here to make your dreams come true. And I get hit up by artists every single day who say, I just got this offer from Sony, I just got this offer from Universal, and I would love for you to take a look at this contract. And as somebody who does review those deals with Universal and Sony, I know exactly what they look like when they're legitimate. And when they're not, it sticks out like a sore thumb. And one thing that is, I'll tell you to always look out for is the email address. If it's an email coming from Universal, their actual domain name should be in that email address. Joe Schmo at Universal Music or umg.com or so-and-so at Sony Music, not Steve Smith Sony at CEO at gmail.com. And that's how most of these scammers do it.
What are some like big gotchas in label contracts you've seen that come to bite people later?
One is not understanding the scope of the agreement. And all these agreements are going to be exclusive for a certain amount of years. But one is the term, is the length of the contract. And an artist would be forgiven in thinking that a longer term contract is a better contract. Sony loves me so much that they want me under contract for 20 years. That's bad for you, because as you progress and as your catalog grows and your revenue grows, you actually have more leveraging and bargaining power to get a better deal. And if that deal was 5 years, then in 5 years you can cash in that new bargaining position for a better deal or go down the street to another label. But you've already given them 20 years at your lowest possible rate. So that's one thing to always look out for, is the length of the contract. Another thing that's very, very popular in the new type of deal is an upstream option. You hear this word upstreaming a lot in smaller indie labels, label imprints, distribution, where essentially they want to have the right to sell their exclusive rights to another label if you get hot. And you're going to see it a lot in agreements. And generally, it's not a bad thing, because that's just where the industry is going. Essentially, these smaller indie labels and imprints understand that they will only be able to take you so far if you really hit a wave of success. Where it is a problem, though, is if the imprint or the like JV label under the big label is also locking you into set terms for the major label, right? Like you are signing this small deal with a small label under Sony. But in doing that, you're also saying they've got the right to upstream you to Sony at this royalty rate, at this advance, on these terms. Now, basically, you're just waiting around for the major to decide whether or not they want you. And if they want you, it's because it's going to be a great deal for them and a bad deal for you. So those are two big ones. The other thing is understanding whether or not it's a licensing deal or it's a deal where the label owns your masters. These deals aren't going to say label owns your masters, artist owns the masters. It usually is hidden in a work for hire clause or a grant of rights clause. And it'll say any rights granted under here will be given to label as a work made for hire, which means that the label will own the copyrights and will own the masters. And that's the language to look out for in a recording deal. Not that I advocate that an artist just review and negotiate a label deal without a lawyer, but those are the kind of magic words to look out for to delineate between, is this a deal where they're going to own the masters, or is this a deal where they're going to license? If it is a license, you will see this is an exclusive license for X amount of years.
Gotcha. And so it's not necessarily that them owning the masters is inherently worse, although I would probably say in a lot of cases artists should try to control their masters. But it's probably more so just that like the artist knows what they're giving up and that they're fairly compensated for that. So if you're giving away your masters, like you should probably be getting a much better deal percentage wise, advance wise, like not like non-recoupable stuff. Like the deal would be different, I assume, if it was owning masters versus licensing masters.
Yeah, you should expect that if you are getting a big advance and you're looking for the most possible money, that you are going to be giving the label your masters, that they're going to own it. And your royalty rate is also going to be lower. Like a traditional label deal where they own your masters, they give you a big advance, your royalty rate might be 20%. But if you did a licensing deal or distribution deal where you take a smaller advance, or maybe you only take the amount that's necessary to record and market the record, then you might get a 50-50 royalty split. So it's a spectrum, and you got to choose what you want from the deal.
In those bigger deals where the royalty rate's 20%, so that means the label's getting 80, the artist is getting 20. That's 20 after they've recouped whatever expenses that are part of the contract, right? So like before, is it, and it was probably different for different deals, but my assumption tell me if I'm right or wrong, is that at first the artist is going to get nothing until they recoup those expenses. And then after that, it's going to become that 80-20 split. But before they recoup, is there often a certain clause where they get a different percentage, or is it the case they just get nothing until they recoup?
So it usually is that they won't get anything until they recoup, but an advance typically is considered a prepayment of royalties. And that's part of why there is that recoupment. If you get paid 50,000, then you've already been paid that first 50,000 that you'd otherwise make at your royalty rate of 20%, right? And then you got to wait till that's covered, and then the other expenses they put in your album. But you don't recoup at 100% of the money that comes in. You recoup at your royalty rate. So if $1 comes in, say it's a digital download, if $1 comes in, the label will take 80%, and 20% of that will be applied to your recoupable expenses.
That feels a fucked up, no?
It's not great. It's not a great system.
Like I feel like a more fair system would be, let's say label gives you, I don't know, $100,000, just to make the numbers easy. And it's an 80-20 deal. So the label gets 80, the artist get 20. So the label is now negative 100.
Mm-hmm.
And like that 100K is including the advance plus whatever marketing costs, recording costs, yada, yada, that are all like recoupable. So to me, I would think the most fair solution would be label makes their 100K back.
Mm-hmm.
Now we're going to split. We're getting 80, artist gets 20. Like, to me, that sounds most fair. What doesn't sound fair is label makes 20% split. Label makes 500 grand. They give that 100 grand. So now 20% of that's 100 grand. So now the artist is like going to start getting paid, but the label's already made 400 grand.
Yeah, no, it's definitely backwards. And the traditional label deal isn't necessarily the most attractive thing in 2025. In fact, when I do work with independent labels, and they're usually labels that are started by artists that want to sign themselves and maybe a few of their friends, I advocate for the exact situation that you just talked about. Why don't we have it so the label can recoup their expenses off the top, and then we'll split the profits based on our royalty rates? Because again, I think that is more fair.
Man. All right, let's pivot to another thing that I've gotten this question a lot, and I'm sure you've gotten this question infinitely more than me. Should artists register their copyrights with the Copyright Office, or do they not need to do anything, or do they use the whole mailing yourself a CD of your own music and keeping it closed thing? Like, what's the scoop on copyrights in America?
Well, definitely don't mail yourself anything, right? It's not worth the stamp that you put on it, because that just doesn't give you any additional protections. It's not like you had this CD that was in this envelope and a dispute breaks out and you get into court and the judge opens it. It's like, oh no, the seal hasn't been broken. So Mr. Southworth, you win the case. That doesn't happen. What's important to know is just kind of how copyrights are created under American law. And they're pretty easy to make. The second you put your original work in any tangible form, I write it down on a piece of paper, I get out my iPhone voice memo and I record a demo, that is now created an automatic copyright protection in my creative work. And that gives me full ownership and rights in that work. Where you get additional protections is when you federally register it. So I don't have to federally register. I already own it. I've already created it for my entire lifetime, plus 70 years after I die. I am now the owner of that work from simply just writing it down on a piece of paper or recording it. But if I federally register it, now I have a few extra goodies, such as the ability to sue for copyright infringement. I can't even go to court unless I federally registered that. The ability to collect statutory damages and attorney's fees in that infringement case. And I also have a public record of the fact that I own this thing and when I created it, which is a lot more reliable than maybe some metadata on my iPhone that I recorded this at this date. I've got an official document from the government that says, as of this date, I own this thing. So you do get additional protections, but most importantly, if somebody were to steal your song, you don't even get to go to court until you register that anyway. So you might as well do that for any of your bigger songs when you release them.
So if, let's say, someone doesn't register and then they find some artist is stealing their copyrighted material, they can just in the moment go copyright it and then take them to court. Yeah. Because like they have that paper trail. I mean, the assumption is they do, like they can show they have the session file on their hard drive that shows it was created in 2017 and this artist released it in 2020. And so they can go copyright it and then they can sue and they have that paper trail. So, right? Is that understanding correct?
That's correct. But you will limit some of the rights that you have. You will definitely be able to still go to court. You will lose the ability to ask for statutory damages, and you'll lose the ability to ask for attorney's fees, which can both be pretty high.
Yeah.
That's because those are benefits you get if you had previously registered it and then an infringement happened. But if it happens after the case, you can only collect your actual damages, which may be good if there is extensive proof of revenue that somebody took from this song. But it could be terrible if somebody just stole it, but they didn't really make any money off of it.
So what would be a statutory damage?
There's a whole range under the Copyright Act. There's a whole range of what this could be. And it goes from $750 all the way up to $150,000, depending on the different types of infringement. And the higher it is, that's the willful, we knew this was wrong, we knew that this wasn't ours, and we did it anyway. And the lesser is really just a sliding scale depending on the specific circumstances and the severity of the infringement.
So overall, registering with Copyright Office, you recommend it to people doing it prior to releasing their song, it seems. What's the most cost-effective way of doing it? Because there's a fee associated with registering it. And I've heard people on the internet say things like, oh, instead of registering every song independently, like throw them on this like compilation thing, and there's a certain amount of songs you can do per batch, and then that gets the cost. Like, what do you recommend just to not spend like hundreds or even thousands of dollars per year registering stuff with the Copyright Office?
Well, it does depend on how much music you have and how much you release. Because if I'm a singer-songwriter and I release 3 singles a year, that probably is worth it to just file on a song-by-song basis, because that registration filing fee is only $65. But if I was a producer and I have 500 beats, or I'm an instrumental artist, producer, and I have a bunch of works that I want to get registered, then that is really going to add up. And I might want to look into maybe setting up a Bandcamp where I have these set on a compilation or on an album, and there I can register up to 20 at a time. And it's still going to be the same $65 filing fee, but now I get 20 for one registration instead of one. So it depends on the artist and how much music they're putting out there.
Does it have to actually be released as a compilation, like somewhere on the internet?
Yes.
For that to qualify? Okay, so you can't just say it's like a compilation. You have to have some type of public. But I guess you could do it in like a very obscure way no one would accidentally find.
You could,
like, let's say you don't want, like, you're releasing a ton of music, you don't want to mess up your discography on your actual Spotify, Bandcamp, whatever. And so you make a website and you have like a product that's on your site, but not like findable from the homepage. And it's a compilation album with 20 songs on it. Like it's a link that's public. Does that qualify, or does it have to be like reasonably findable?
Yeah, you're getting a little too like, secret agent there. I think the way that I say is that it has to be publicly findable and that somebody could actually find it. The way that I do it is I'll have an artist set up a Bandcamp and just put that on the Bandcamp, and they could even say, this album's $200, whatever it is. But the reason why that is effective is because when that application is being reviewed by an attorney at the Copyright Office, they might very well go looking for that album and they want to see it somewhere.
Gotcha. So it has to, it shouldn't be this thing that you try to like hide per se, because you don't want it should be reasonably accessible. Now, I guess on the flip side, what if your album's longer than 20 songs? Like the longest album I've released personally, well, of my own music, has been 19 songs. But I know people who do instrumental stuff, lo-fi, hip-hop, sweet type stuff that release albums. I know one artist that released a 100-song album, which I don't know what distributor they used, but wow. DistroKid allows up to 35-song albums. So what do you do in that case? Do you just file twice and like reuse the name of the album? Or
I will say I haven't run into a situation where I've had to file a 100-song album, thankfully. But what I would imagine would happen is there are general guidelines. You've got up to 20 songs per application. That doesn't mean that the Copyright Office isn't completely inflexible. You just have to state a special reason why the 50 songs you're putting together is one protected work. It's going to be a lot harder to register those all at once if you have different authors on all of them, because, and we can get into this as well, there's two copyrights with music. There's a copyright for the sound recording, the master, and there's the copyright for the music and lyrics, the composition, which is also known as publishing. And if I wrote a song and I own the master, then I can register that all together in one application, right? Because I'm the one and only owner. I can register a sound recording copyright, and then I can just click a simple box and write that I also wrote the lyrics and music. And now I have both the master and the composition registered in one registration. So I don't have to go and pay $65 twice. But
gotcha.
And that'll be true if myself and you wrote and recorded and owned all those 50 songs on that album. But what if you and I wrote one song and then I wrote a song with somebody else and this, that, the other thing, and I wanted to get both the master and the composition under one application? It's not going to happen because it has to all be the same authorship. And I could do it all as the sound recording, but then I'd have to go back in individually and register the compositions. That could be pretty labor intensive and costly.
We were talking about royalties a little bit ago, and royalties in the music industry are kind of an archaic beast that's like evolved from, before the days of recorded music. And they came up with these like laws to protect those people who were performers so the recorded music wouldn't hurt them. And then there were other laws introduced to basically protect sheet music companies and whatever. And now we have this complicated system of performance royalties and mechanical royalties. And then there's like the distributor royalties. So I guess, let's say someone streams your song on Spotify. What are the different royalties that you get and how do you collect them?
I love this question so much. Okay, so if you are just collecting your music royalties from your distributor, and you haven't checked a box that said you also want them to collect royalties for you, which is a whole different thing. But if you just are uploading to DistroKid and they're paying for your sales and streams, you're only making about 70% of the money that came in for that sale or stream. And it's the lion's share for sure, but the rest of that goes to publishing. That other 30% is more or less split between your performance rights organization, BMI or ASCAP in America, or PRS if you're in the UK, and a bunch of other performance rights organizations throughout the world, and the Mechanical Licensing Collective in the US, which collects your mechanical royalties. And just really simply what these are and what they represent, the performance royalty compensates the songwriter for the public performance of the song. And a public performance can be any number of things. It can be a stream, it can be a play on the radio, it can be a live performance at a concert, or a performance over the sound system at a bar or restaurant. All of those things can generate performance royalties. And then you have mechanical royalties, and that compensates the songwriter for the reproduction of the song. You often will think about this in the context of a cover song, and that's usually something that's given by Harry Fox Agency. If I wanted to record a cover of Eric Clapton and I wanted to print that on 1,000 CDs, I would need to get a mechanical license to be able to do that. I have the permission to do that under copyright law because I don't need Eric Clapton's consent to it so long as I pay those statutory mechanical royalties. So anytime there's a reproduction of that song, that's where mechanicals come in. And on the streaming side of things, that would be, think about it, a download or a stream also creates a reproduction. Even a cookie is a temporary reproduction of the song itself, and it creates a royalty. And that's distributed and collected by the Mechanical Licensing Collective. So that's the three main ones for the stream of Spotify. It would be your distributor, that'd be just be your master royalties, your performance rights organization, BMI, ASCAP, and your mechanicals, the MLC. And there's also this whole other thing that wouldn't be impacted by streaming, but it could be on, say your music's played on Pandora or it's played on Sirius XM. That's where Sound Exchange comes in. That's your digital, non-interactive royalties. It's America's best estimation at performance royalties for the master. Because in every other country in the world, every other democratic country, except for North Korea and Afghanistan and America, we get paid when a sound recording is performed publicly. But because of the lobbying back in the day with radio, record labels and artists don't get paid for their songs being performed on the radio. And that's what's known as neighboring rights. And so our version of that in America is the digital non-interactive streams like Sirius XM and Pandora. And I will tell you, having seen those Sound Exchange statements, if you get a song on Sirius XM, you're doing pretty good because it pays like $50 per play. It's pretty awesome.
I've seen people get their music in the rotation on like not even like a mainstream pop Sirius XM station, but like a metal one or a rock one, and make like 10 grand over like a period of a few months or something.
It's insane.
So Sirius XM, it's not like something that anyone can just get. It's very much a relationship thing where if you know the right people, you can plug your music to them and you might get it. I don't know anyone that can like reliably do it. I'm sure there's like PR agencies that have connections and stuff, but it's not something you can control. But if you do know someone that can get your music in Sirius XM, it is serious money.
And you just make sure that you register that as both the rights owner and as the featured artist on Sound Exchange, so you can actually collect that money.
Right. Wow. That was, I think, the best explanation of music royalties I've ever heard. So thank you for that.
Well, thank you.
I have several follow-up questions. I don't know if I even remember them all. How do they even know that your song is part of the system and at Harry Fox specifically? Like, is it when you register your music with the MLC, then now it's added to the Harry Fox Agency's database? And that's kind of the first part of that question. And then the second part of this question is, you mentioned the artist can't really say no about someone covering the song if someone buys the license. So is it that if you register with the MLC, now it's in Harry Fox, and anyone can cover your song as long as they do the licensing, and you have nothing to say about it?
These are great. These are great questions. Okay, so first, Harry Fox Agency. Harry Fox has been around for a long time. And when the MLC was created in 2020, it came out of the Music Modernization Act. It was 2018, the Music Modernization Act, the Copyright Act was updated to add these other protections, and it created the MLC. And the MLC is a government entity that was essentially founded by the Harry Fox Agency. Like all of the back end infrastructure is Harry Fox. But
Gotcha.
the way that you become a writer or a publisher that can give rights under Harry Fox is that you sign up and become a member. And most major publishers, writers do that. I mean, it's pretty rare to find a catalog that isn't represented under Harry Fox. It's just they're the known place to go. And even if you were to use something like Easy Song, they're likely just going to Harry Fox anyway, because that's where the rights are. But as far as can somebody say yes or no to a cover song request, that gets into what's known as a compulsory mechanical license under the Copyright Act. And what that says is that anytime I release a song, from the moment it's released, anybody else is free to cover it as long as they pay me the statutory mechanical license. Like the copyright law states what that amount is, and it changes over time with inflation and what have you. But it's compulsory, meaning I can't say, Andrew, no, I don't like your music. I don't want you to cover the song. Basically, as long as you hand me the money, it has to go through.
Yeah. But honestly, like when hearing it explained, it all makes kind of perfect sense. But I have a feeling, myself included, most people have not heard it really explained, because for the most part, it's like you upload your music to DistroKid, CD Baby, whatever, and then someone on the internet says, "Oh, you're not making all your money," and then you go to you pick a PRO, and then you go to MLC or whoever, and you just do it because someone says you're going to make more money, and then you see some checks coming in, and then you're like, "Cool, I guess I'm making all my money." But it's rare you ever hear it just in plain English, like the why. So I appreciate you breaking it down into plain words. And very much related to this, you've probably heard of a company called Song Trust, right? Where do they fit in this? I've talked to some people that work there. I did a video covering Song Trust before, but even after that, I was still a little bit confused. And honestly, I'm not entirely certain nowadays exactly what they do. My understanding is they just make my life easier by collecting on my MLC money for me and international equivalents of that. And then they collect the PRO money for me, but also the international equivalents of that. Is that correct?
Yeah. Song Trust is a publishing administrator, meaning that in exchange for a percentage of the money that they go out and find you, which I think is 15%,
yeah, it's like a $100 setup fee and then 15% of whatever they get you.
So they go and they will register your works with the MLC, with your PRO, if you haven't done that already. And then you're right, with any foreign equivalents of those for your performance and your mechanical royalties. Anything on the publishing side, they will go and collect. And so if you were just listening to everything I said and you said, man, Ryan, that's really great, but that sounds like too much work, then consider getting a publishing administrator. Just know that they're not all created equal. Song Trust is one where you can join and then you can terminate it, and then there's going to be a 1 year kind of collection grace period, like because there's going to still be money that comes in after you terminate that was actually earned while they were working for you.
Yeah.
So that's why they have that. But there are other pub admins that are much longer term and function more like a publishing deal and can lock you down to longer deals. So just make sure you understand, especially if you're with a distributor and you check that box that says, yes, I want you to register and collect my publishing. Just make sure you read that fine print and you know what it says, because it might not be great.
So last topic, just because we've been going for a good amount of time, AI music.
Let's do it.
You've been pretty outspoken about AI music and how we might be able to keep it like fair. Because right now, like there's practically no rules against. Well, I don't know if there's rules or not, but like all the companies that are training AI tools are. It seems to be what they did is they just ripped all the music off of every streaming service, put it into their model, and trained off of everyone's music without their permission. Nor did they compensate any of them. Same for ChatGPT. They trained it off like the entirety of the internet, YouTube videos, even like a lot of YouTubers have found out that their videos have been used to train Sora or other ChatGPT or OpenAI related tools. What do you think will happen or should happen to make these systems more fair for actual human creators?
Right now, we're in the wild west of AI, and you have companies that are very openly saying, if we had to go out and get the permissions on the front end, these tools probably never would have been built because of just the sheer amount of data that they had to feed these things to make good models. And from a technical perspective, I can see that. But from a legal and ethical perspective, that makes me want to puke. So yeah. What I think about this now is there are companies that have done it the right way. There are certifications that you can apply for if you are an AI company to show the public that you have fairly trained your model that respects the rights holders that you trained it on, that everybody gave their consent, that they were compensated, that they got credit. And the certification is actually called Fairly Trained. If you see Fairly Trained on a AI website, that means that they went through some very rigorous testing and they had to show how their algorithm was trained. And so that's one of the things. I think that the models that you described, ChatGPT, Suno, Udio, they're all getting sued at the wazoo right now. And some of them, ChatGPT is kind of going back and trying to get some licenses. You know, they've got a license with, I think, the New York Times and Reddit, and they're trying to get some permissions. But unless you get permissions from the major studios and publishing companies for this music AI, you're in a real problem. The argument that the AI companies are making is that it's no different than how we as humans learn music. We listen and then we iterate and then we create new music. Well, I don't know about you, but I can't listen to millions and millions of songs and then keep it in that brain and then be able to recite it in a kind of perfect verbatim way.
Also, if you could memorize and listen to millions of songs, the process of doing that, you would dump so much of your own personal money into the music industry. Like you'd be buying CDs, you'd be buying downloads, you'd be paying for monthly streaming subscriptions, you'd be generating ad revenue on YouTube, all of which would pay the artists on a per usage basis as a human. And so that's personally to me why another reason why that argument people make about, well, humans don't license the work on the things they learned when they played guitar. It's like, well, it's not the same. Like this isn't a human learning it and writing it for you. This is like it's not learning the same way, basically.
And we know that in these lawsuits, they have linked to YouTube videos where people have used these platforms and the output actually gave them producer tags. people's actual voices, right? So you can't say it wasn't trained on this if it's able to give that back to you. So I think that we're going to see a lot of AI companies either go legit or go belly up in the next couple of years. I think with the music ones, these lawsuits aren't going anywhere. So whether they want to stick it out and see if they'll win in court, or if they're going to settle and give the major labels and publishing companies equity in their company, just like Spotify did when they got going, remains to be seen. But I think that the AI tools that should rise to the top are the ones that are doing it in an ethical way. I just really don't love the way that music, in particular, music AI tools are being marketed as a way for non-musicians to create music. Look at all this great stuff that we have here. You can sound like Drake and you have no skills that you need, and you can just click a few buttons and make a song. No, we don't. Making music is the fun part of it. All the other stuff kind of sucks.
Yeah.
So don't take that
true.
from us.
I saw that thing you posted about like the founder of Suno, I think it was, talking about how like most artists hate the music making process, which is like there are parts of the music making process that aren't enjoyable, right? Like no one really enjoys tuning vocals, right, or quantizing drums, but like most artists make it because we love making music, at least the whole making music. We might not love these little individual pieces, but we love the whole process. So I thought that was it was obvious that that guy that said that is not a musician, or perhaps doesn't even know any musicians. Because,
right.
Like,
no,
how could you think that?
It's a tech company that just happens to make a music product.
Yeah.
They're not part of the music community. So what I think is going to happen is we're going to see changes in copyright law, for good or for bad. Talk about what you can and can't do with AI music. Because right now we are interpreting the 1976 Copyright Act, which didn't really contemplate AI. The Copyright Act says that right now they don't need any changes. It stands up just fine. I think we do. So we're going to see that. But the other thing is all this voice cloning stuff. That
like
is a
Voicify or Jammable.
There's a million.
And they're fun to play with. Like, and there's some artists I've heard that have done some magical things. Big shout out to this artist called Boy What. He's a metalcore artist, and he makes these badass metalcore songs from scratch. He sings them all, does all the screaming, and then he replaces all of his voice with characters from SpongeBob.
Oh wow!
And it is amazing, and the amount of effort and work goes into it. But I'm sure he's probably breaking some law. Like, he's not paying to license SpongeBob characters, so the platform trained on those characters and the creators of those characters aren't being compensated for that work. So like ethically, it's squirrely. The creator, I don't think, should be in trouble for that. But like Jammable or whatever service he used clearly didn't pay Nickelodeon for the SpongeBob rights.
Yeah, the copyrights are one thing because it is pretty, in my mind, it's pretty black and white. You have these rights as a creator, and the right to distribute and perform and to reproduce. And what the training was violated that. The voice cloning is a lot trickier because there is no federal law on image likeness rights, which means that you have to default to state laws. And there's only half of the states have any type of protections, and they vary from state to state. So if you're in one state that doesn't have any laws making it illegal to use somebody's voice and likeness, no rights. If you do it in a state that has very strict likeness laws, like Tennessee in the Elvis Act, then you have rights. And I think that we need to have a federal uniform law, just like copyright, So we don't have to worry about those type of nuances. It's either a yes or a no.
So I think that's a great point to end on. But yeah, all your links are down below. Where should people find you aside from ryanschmidt.esq?
Yep. Yeah, they can find me at ryanschmidt.esq. ESQ is just short for Esquire, so lawyer.
Yeah.
They can find me on Instagram, very active there. Post daily on there about different cases going on, different contract clauses you need to look out for, how to collect your royalties. I'm also going to be launching a new YouTube channel that should be live by the time we post this. And I'm also part of this really cool app called Foundation. And it's essentially like Duolingo, but for the music business. And we are in beta right now, and that'll be launching very soon. You can find more information about that in my Instagram link in bio, but I'm excited about that as well.
Sweet. Thanks for coming on, man.
Thanks so much for having me.